Welcome to another edition of the Friday Show, brought to you by the Jockey Club. Hey, it's opening week at Saratoga. Next week, opening at Del Mar. Exciting racing time. Don't forget, August 3rd is the date of the Jockey Club Roundtable. The agenda is up, and I believe one of the speakers is joining us this week. By the way, I'm Ray Paulick, joined by Joe Nevills. Lisa Lazarus, CEO of the Horseracing Integrity and Safety Authority. I believe you're speaking at the roundtable. Is that correct?
I am, but I think it's in a panel interview format this year.
Yeah. Well, we'll try to do a spoiler so that everything you're going to say that day, you're going to inform our viewers today.
Sure.
We've had you on before, and it's probably a month ago when the HISA program, anti-doping and medication control program was underway for a little bit, and now we've had a lot of activity as far as positive tests for controlled substances, some resolved cases and some unresolved cases, and some controversial cases involving banned substances that have led to provisional suspensions. How do you think the rollout has gone so far with the various, there's been a lot of criticism of some of these.
Yeah. Generally speaking, I'm very pleased with the rollout. I would sort of summarize it as saying that the program is doing what it is intended to do. The program comes from the World Anti-Doping Code. It is almost exactly similar to the program used by all of the Olympic sports, including the equestrian Olympic disciplines, so including their equine and medication control program. It's based on the philosophy that there's a greater good, there's a greater sport, and the integrity of the sport that needs to be protected, that ultimately the program is set up to protect the trainer, the responsible person who's competing cleanly, following the rules, so that they're not at a disadvantage. And I think the concept that's been most sort of surprising or maybe new to the industry is this concept of a provisional suspension, which is not a summary suspension, which I know many people are sort of used to that term. Basically, the calculus is when a horse tests positive for a banned substance, which is a doping substance, not a controlled medication, something that, at least in the view of our program, should never be in a horse's system, has no legitimate purpose in a horse, okay? At that point in time, when that A sample comes back, the calculus of the program is it is too high a risk to allow this person to continue training horses, continue competing, both to horse welfare, but also to the trainers that are competing against him or her, because that wouldn't be fair to them. I think one way to really sort of one example that illustrates this, I think particularly well, is we have one trainer who's had multiple positives for the same substance. Now, he will have his day in court, and he may have very good explanations for why that substance got into the horse's system. But the net is that it's there. So would it be fair? And you have to assume that it's he's using it in the majority of his horses, if not all of his horses. Would it be fair for trainers to continue to have to compete against him, knowing that his horses have a performance enhancing substance in them while the case is going through the motion? So the provisional suspension is all about what should the status quo be? While the case is going through the steps that it has to go through, should the trainer be suspended or not? And previously, one of the reasons why it made a lot of sense to always kick the can down the road is that trainers could continue doing what they were doing during the pendency of a case. But the way that this program kind of flips that concept, I think, is really important for its integrity and really important to make genuine change.
I feel like I'm seeing a lot of names and substances pop up on this list that I haven't seen very frequently in the past. What is being sort of done differently from what we've seen from past testing processes as I've seen some of these names show up on the list?
So I think the difference between HIWU and the sort of previous racing commission scenarios is that the contracts with the laboratories for what they test for is between HIWU and the laboratories. And that list is based on international intelligence, research, sort of science that our people on the science are able to basically glean about what might potentially be out there that trainers are using that they shouldn't be using. And so I think it's not that the labs are doing anything different in terms of their capabilities. It's just that we're asking them to test for different things than was the case previously.
some of the banned substances are drugs or substances that previously were class 4 drugs. I think isoxaprine is an example.
Yeah.
I don't know the chemical, but the Regimate is the brand name for a drug that landed a provisional suspension for a trainer. Now that was in a male horse. Regimate is for fillies.
Correct.
But still, it's not a sort of a banned substance in the general horse world. How did HISA arrive on some of these substances being listed as banned versus controlled?
So we have an ADMC committee that's comprised of 7 people who've been appointed by sort of the nominating committee through the process that Congress created. And they're the ones who are tasked with developing the list. And they have a fair amount of strong expertise on that committee to begin with. But then they also draw from, the International Federation of Horse Racing Authorities, from other jurisdictions, from science, from new developments. And they also look at, drugs that may have the potential to cause serious horse welfare concerns. And so they go through that analysis, but ultimately the test is whether it has any legitimate purpose in the horse, or whether or not it's essentially been approved by any regulatory authority for use in animals. And the alternogest one, which is Regimate, is a slightly peculiar one, because it is absolutely permitted in female horses, but it's not permitted in male horses. And it'd be like, why would you give the birth control pill to a guy, kind of thing? That's probably a rough analogy, but that's essentially what it is. So that's why, now that's not my determination. I don't have expertise by any means in that area, but that's the process.
Continuing along the lines with the Regimate issue in particular, I was listening to an interview with Mike Willman recently, talking to someone at Canterbury Park about the suspension of Mac Robertson over the Regimate. Mm-hmm. And it seemed like there was a lot of confusion from the track side over when horses should be scratched, why, when to put them back on. It seemed like there was kind of a breakdown of communication there. Can you talk a little bit about just how tracks are being informed here, what you've sort of learned in the first few weeks of this going on, and how things can be improved, and go from there?
No, absolutely. So let me start with the fact that the statute creates certain challenges for, and this is HIWU actually, who's running the program day to day, the Horse Racing Integrity and Welfare Unit. And the statute makes clear that no one is entitled to information about an impending suspension other than sort of the interested parties, and where HIWU has a voluntary agreement with the Racing Commission, also the Racing Commission. So the problem, and it's a legitimate one that we need to fix, is that there was no kind of legal vehicle to get that information to the tracks ahead of time. And the program puts the onus on the responsible person to scratch the horse. That being said, like from a practical standpoint, I've communicated with HIWU after that all sort of came to light, and explained to them that, in the sort of racing world, we've got to find ways to allow people to do their job that don't put our, the program at risk. So we've now come up with a system where there will be an email communication sent to everyone on the track that needs to know, kind of laying out what the steps are, even though they're not entitled to like the formal notice with all of the details about the violation. They'll still get the information that they need in order to do their jobs properly. So yes, that's absolutely a kind of kink in the system that we need to work through, and we are working through.
So basically an email goes out, the horses from this trainer are scratch these ones, like these ones can't go in.
Exactly.
So on that arm's length,
with an explanation also that they're, it's because
right. On that arm's length, it looks like there's like an arm's length arrangement between HISA and HIWU, which I wasn't aware of before. Yeah. So HIWU, the Horse Racing Integrity and Welfare Unit, is responsible for testing and for presenting the cases when there's a failed test. Then where does HISA come in? Are they responsible for adjudicating then?
No, let me explain this. And let me just take one step back. So you may recall that the U.S. Anti-Doping Agency was very involved when we were getting them, and they played a very helpful and positive role in getting the bill through the various stages. And a lot of their sort of philosophy shaped what the legislation looked like. And their view is that the Anti-Doping Agency has to really have separation and ability to objectively do their jobs without intervention from the regulator. right? And so the way the law is structured is that HISA does sort of two things. We have the pen to write the rules. So we actually write the rules, which is the ADMC committee, obviously with support of staff. And we ultimately, we write the rules and we appoint the anti-doping agency. But HIWU is the one that comes up with the test plan, carries out all of the testing, and they adjudicate all of the cases. And I think probably what was surprising to you is we had a little exchange where I explained that I actually only find out about a trainer being suspended the same time that the trainer does, or the same time the notice goes out. I'm copied on those notices, but I don't find out ahead of time. That is, protected. And the philosophy is that in order to really deliver a fair, balanced, objective program, nobody should have any influence over how cases are adjudicated or how they're notified or how they're, they should be, if there's a positive test, there's a notification process and there's a clear pathway. And that, even though I know I personally wouldn't intervene, it's really a protection against the regulator saying, this is actually a good guy. Maybe like put this one off the side or don't be so harsh. We have no way. Obviously, I would never have any reason to do that. But we also have no way of doing that under the program.
Mm-hmm. Can you talk a little bit more about the adjudication process? Like, who is making the decisions on these for ones that have already sort of been resolved? Like, where does the rubber stamp come from on this? That something is either, good to go or needs further, I guess, punishment.
Sure. So the way that it works is, first of all, that the kind of programs for the doping substance and the controlled medication are different. But essentially, let's take a controlled medication. The responsible person will be notified that they had an overage for bute, let's say, right? And then and essentially what HIWU will do is they'll lay out what the sanction is, okay, what for a first time offense. And they will give the covered person the opportunity to either say, I'm just going to accept the sanction. I don't want to pay for the B sample. I know I gave my horse bute. I obviously didn't withdraw early enough. And for a first time bute offense, it's a $500 fine and disqualification. There's no days with it. So they may say, you know what? It happened. I'm just going to acknowledge it, put it behind me and kind of move on and learn from it. If they do that, that's what then it's a resolution. HIWU and the covered person agree and the covered person signs off. And that's what you're seeing now on the resolution page, the ones that have accepted consequences. If they don't want to take that route and they say, I'd like to have a B sample, then it goes to the B sample process. If after the B sample comes back, they still want to challenge the alleged violation, if it's a controlled medication case, it goes to something called the internal adjudication panel. That panel is comprised of, through an interview process and a resume and a reference check and all that, is comprised of primarily stewards in other jurisdictions who would only be able to take cases from jurisdictions that are not their own, and also other equine lawyers and professionals who are familiar with these cases. And there's no cost or fee to use that system. And so if they want to appeal, they go through that system. And then if ultimately they don't prevail, then they can appeal to the FTC and kind of do the regular channels. Under the banned substances case, it's a little bit different because obviously the consequences are more severe, potential consequences. So if they decide they don't want to accept the consequences, they appeal to the actual arbitral body. And that is a set of private arbitrators from outside of racing who are appointed by JAMS, which is essentially a private organization that oversees arbitrators. And they actually do all the vetting, and they will assign, Mr. Green, arbitrator 1, to this case, and then it'll essentially proceed like any arbitration, which is like a private, almost like a private sort of mini trial. And they'll get to present evidence and argue their case and et cetera. And then ultimately that arbitrator has the obligation to write a decision and to make findings. And then of course the covered person could always appeal that decision if they're not satisfied with it to the Federal Trade Commission and ultimately to a federal judge.
Switching gears a little bit here. There was a notification put out by HISA saying that it was not going to enforce the penalty phase against trainers for the intraarticular injections before workouts.
Yeah.
And I heard from a lot of trainers who said, they're starting to play favorites here, that, somebody got to Lisa Lazarus and said, hey, we can't punish these trainers. Saratoga's coming up. So we finally did find out who the trainers were based on the horses that were provisionally suspended for this. You did enforce it for injections before races, but not before workouts.
Yeah.
Why did you do one and not the other? And was it really that complicated for trainers? Because I saw some of the educational materials. It seemed pretty clear.
So here's the thing, a couple things. One is I got a call from HIWU quite early on saying we're getting a ton of these violations, and you've only seen, I think maybe about 20 are posted, but we're still notifying. So it's going to get up to like 40 or 50, I think, from this interim period. And probably more significantly is that the sanction is a 60-day suspension for trainers. And to be really honest, I've always said that we're going to make some mistakes along the way. We're going to get some things wrong. And if we get them wrong, we're going to adjust. And when you look at the overall kind of sanctioning scheme of the Class A, Class B, Class C substances, being off one day for an injection for a workout seems very much out of sync with the rest of the sanctioning table. And when I took that question, first of all, I didn't know who any of the trainers were. As I said, I had no idea what the identities were, nor would I care. I mean, when you're talking about like 30, 40 in the beginning, that's not really relevant to me. But nonetheless, I took that question to a lot of different sort of experts and sort of racing aficionados and said, like, does that make sense to you? And unanimously, everybody said that just makes no sense. And so we took it back to the ADMC committee, who actually has the pen, to write the rules or to modify. And I think I've explained before that we can't, the Federal Trade Commission has to approve any rules that we make or any rule changes. But we do have some limited ability within our system to determine not to enforce a section of the rule, as long as we are being, less strict and not more strict. And given, how early we were in the program, and given the fact there were so many trainers affected, and the fact that really everyone agreed that the sanction was too onerous, we ultimately decided to still impose the suspension on the horse. So there was some penalty, but not to in this early period impose the same sanction on the trainer. And ultimately, we've taken the rules sort of back to the ADMC committee. And I do anticipate that when we make an announcement, tomorrow, that there'll be some changes to the rule, that or some modifications on enforcement that will continue to be in place when we start to enforce it fully. On the racing question, the racing prohibition is very well understood. It's been in place in most jurisdictions for a long time. It was, while we did talk about and mention the workout rule, and Mary, I think Dr. Scalay certainly discussed it, the racing rule was very heavily discussed and very sort of heavily featured. And there was only one person since the start of the program that's violated that rule. And so the consensus was there was no reason to do anything different with the racing rule.
Looking at the appeals process a little bit, we've mentioned sort of maximum fine times. You mentioned 60 days. Some of the notable suspensions have been for up to 2 years, but then they, the process goes through, they decide it's contamination, what have you. How quickly can those gears get turning to sort of get something like this either overturned or cleared, or get that moving so you can get back out to training?
Okay, so first of all, I think one of the things that's really important for trainers to remember or to realize is that, yes, the sanctions can be very severe and different than what they're used to for a doping substance. But also, the entire framework is based on fault. So if you truly have no fault, you will not have a sanction. And that's different from what a lot of racing commissions used to do. Because, for example, I'll use the Ray Handel case. That was tested positive for a banned substance. The first suspension was imposed, was triggered. Within, I think, 48 hours or 72 hours, he was able to produce some evidence to HIWU that HIWU looked at within 24 hours and said, you know what, there's a risk here that he may actually prevail on the merits. And even though we don't know yet, there's too high of a risk to keep a suspension in place, because we don't want to ever have a situation where somebody is unfairly suspended for a period of time when they shouldn't be. So it was lifted, I'm going to say, within 5 days of being imposed. And so we have those mechanisms to do that. And B, a staff and an organization that's willing to react quickly and take information in. Now, we also have an atypical findings policy where you have 27 substances that if they're actually found in the system, they go through a different process to determine whether or not they're more likely to be contamination than not. And if they are determined to be likely contamination, they won't ever be notified as an alleged violation. So I think we have, it's going to take some time to get it perfect, but I think we have the fundamental tools in place to have a program where we are finding and punishing the stuff that we should be, and we are trying to deal properly with the violations that a trainer could never control. Mm-hmm. And I want to make one more point about fault, because I think it's important. We look at environmental contamination as being a no fault occurrence, right? If a trainer has a feed that's contaminated, you got to feed your horses, and the horse eats the feed, like there's nothing a trainer could have done to prevent that. That's different from a human drug getting into a horse's system. If you have a prescription for a human drug, there are things that you can do as a trainer to reduce the risk of the horse consuming your medicine, right? And so that is viewed differently. Now, it's all a fault continuum. If your horse tests positive for a medication you're taking, your fault is likely going to be less than if you're intentionally doping a horse to enhance performance. But it's not going to be zero, and it's not going to be the same as environmental contamination, because trainers should have practices in place to essentially reduce the risk or the likelihood that a human drug is going to come into their horse's system. And that's I think an important, and then you have, if it's an employee, it's probably, slightly less fault than if the prescription is yours. Right. And that's the assessment the arbitrator will make on fault.
When these cases are resolved, say the Ray Handel case, or there's other potential contaminations, how transparent will HISA and HIWU be in terms of explaining where it came from? I know there's a case right now where a supplement might be the cause of something. Will that come out in the end when the case
100%? If HIWU will test anything that they're either provided or that they seize in a barn search, and if through testing and certainly through interaction with the manufacturer, there's a determination that a supplement has an ingredient that's not listed, that is banned under our program, we will absolutely make that public. I mean, obviously education is so key. And one of the things, HIWU's been saying for a while now, even prior to the launches, you got to be really careful about supplements. It's a problem in every sport. You don't know what's in it. And obviously the manufacturers are incentivized to put ingredients in it that actually have an impact. And that often means that they shouldn't be given to either the human or the horse. So, covered persons have to be very careful and very leery about supplements.
One last question, Lisa. You've been through this before with the FEI, which is the governing body for a lot of other horse sports. Were there growing pains in that program as well? And on the specific subject of supplements, how did that sort of change the mentality of using some of the supplements?
Yeah, so they absolutely went through the exact same sorts of growing pains as we're experiencing now in racing. That program was put in place. This program was put in place in horse sports, show jumping, dressage, eventing, endurance. In 2010, I kind of led that initiative with a team at the FEI. And, it was 133 countries, and there was a lot of pushback and a lot of concern. And there was, obviously a period of adjustment. But ultimately, it's the program that, in my view, has, allowed equestrian sports and the Olympics discipline to be considered incredibly clean, well-run, to have integrity, and to preserve their place in the Olympic program. Supplements have always been an issue. If you go on the FEI website, you'll see a lot of warnings about supplements. It's a problem because it's completely unregulated. Right. So you can say whatever you want that your supplement might do, and you can list, ingredients that are there or not there, and no one's testing that, and that's really a concern. And so, given this new program, trainers should not use supplements unless they're absolutely confident in what they contain.
All right. Well, listen, we appreciate you taking the time again this week. I know you're busy. There's a lot going on with HISA and HIWU. And we look forward to your remarks at the Jockey Club Roundtable on August 3rd.
Great. Well, thank you so much. It's terrific to be here.
Okay. Thanks, Lisa. We'll see you all next week.
Support award-winning independent horse industry journalism and become a Paulick Report Insider on Patreon. For as little as $5 a month, insiders get access to exclusive Q&As with Paulick Report staff, insight behind our editorial process, exclusive opinions and on-site analysis, Paulick Report merch, and more. This is not a paywall. The website you know and love will always be the same. But if you want more, and you want to make our coverage even better, visit patreon.com/Paulick Report and become a Paulick Report Insider today.